If I'm broke, I file bankruptcy. If I'm really broke, I file Chapter 7. If I make money, I file Chapter 13. If I own a company, I file Chapter 11. That's how most people think this works, but that is not how this works. Bankruptcy chapters are legal categories triggered by income, debt structure, assets, and objectives and are not lifestyle labels. How does the law actually determine which chapter applies and why the wrong chapter can cost people serious money?
Bankruptcy law exists for two simultaneous purposes. First, to give honest debtors relief, and second, to ensure creditors are treated according to uniform federal rules. Notice what is missing. Bankruptcy is not designed to protect financial recklessness, guarantee zero consequences, preserve every asset, or function as a negotiation tactic without scrutiny. It is a structured federal process under Title 11 of the U.S. Code. For individuals, 3 chapters matter: Chapter 7, Chapter 13, and Chapter 11. Most individuals file under 7 or 13, while Chapter 11 is less common, but extremely important in certain cases. Before we compare them, we need to establish one principle. The chapter is not primarily a choice, but more of a legal fit to the circumstances. Chapter 7 is commonly called liquidation. It is the fastest and most direct form of bankruptcy relief available to individuals. Here's how it works structurally. You file a petition. An automatic stay immediately stops collections. A trustee is appointed. Non-exempt assets may be liquidated. Qualifying debts are discharged. Typical timeline, 3 to 6 months. There is no repayment plan, but there is a gatekeeper. The law compares your income to the median income in your state for your household size. If your income is below median, you generally qualify. If your income is above median, then the court runs a formula analyzing disposable income. If the formula shows you can meaningfully repay creditors, Chapter 7 may not be available. This is critical. Chapter 7 is for people who cannot repay their debts under structured repayment standards, not people who prefer not to. What is typically discharged? Credit cards, medical debt, personal loans, old lease deficiencies. What usually survives? Child support, most student loans, recent taxes, and criminal penalties. People often believe Chapter 7 means lose everything, but that is inaccurate. Each state provides exemption laws protecting primary residence equity up to limits, vehicle equity up to limits, retirement accounts, and personal property. However, if you own substantial non-exempt assets, such as rental property, valuable collectibles, or have high equity, then Chapter 7 may expose them. That risk changes the chapter analysis. Chapter 13 is sometimes described as a wage earner's plan. That's partially accurate. It is designed for individuals with regular income who can repay a portion of their debt over time. Instead of liquidation, Chapter 13 imposes a court-approved repayment plan lasting 3 to 5 years. Here's what changes compared to Chapter 7. You keep your property. You make monthly payments to a trustee. The trustee distributes payments to creditors. After completion, remaining eligible unsecured debt is discharged. There are 3 primary strategic reasons to use Chapter 13. 1. Curing mortgage arrears. If you are behind on your home, Chapter 13 allows you to stop foreclosure and spread missed payments over 3 to 5 years. 2. Stopping repossession. You can catch up on car payments under court protection. 3. Protecting non-exempt assets. If you would lose property in Chapter 7, Chapter 13 allows you to retain it, provided your repayment plan accounts for its value. Chapter 13 has statutory debt ceilings. If your secured and unsecured debts exceed those limits, Chapter 13 is unavailable. That is where Chapter 11 becomes relevant for individuals. Chapter 13 is structured, supervised, and rigid. It works well for stable income situations. It does not work for large, complex debt structures. Most people think Chapter 11 is only for corporations, but individuals can file Chapter 11. Historically, Chapter 11 was too expensive and procedurally heavy for most individuals. That changed with the introduction of Subchapter V. When does an individual use Chapter 11? Typically when debt exceeds Chapter 13 limits. The individual owns a business, real estate holdings are complex, or financial restructuring requires customization. Subchapter V streamlines Chapter 11 for small business debtors. It removes certain procedural burdens. No mandatory creditors committee in most cases. Simplified plan confirmation. And greater flexibility in restructuring. An individual operating a small business may qualify. Chapter 13 is a fixed 3 to 5 year plan with strict debt caps and a trustee administers payments. Chapter 11 has no Chapter 13 debt caps. The debtor remains debtor in possession. There is greater flexibility in plan design, more administrative complexity, and higher legal cost. Chapter 11 is often the tool when the financial situation is too large or structurally complex for. Chapter 13. Possible asset liquidation. Best for low income, primarily unsecured debt. Chapter 13. 3 to 5 year repayment plan. Regular income required. Asset protection tool. Debt limits apply. Chapter 11. No Chapter 13 debt caps. Custom restructuring. Often used by business owners. Higher cost and complexity. More flexible but more demanding. The differences are structural, not emotional. Now the critical question. What actually decides the chapter? Income level. Below median income? Chapter 7 likely available. Above median with disposable income? Chapter 13 may be required. High income with large debt exceeding Chapter 13 caps? Chapter 11 may be necessary. Bankruptcy does not automatically eliminate student loans, guarantee credit recovery, fix unstable income, or prevent future debt. It creates legal breathing room. But Chapters 13 and 11 impose strict compliance requirements, mispayments, case dismissed, fail reporting obligations, protections collapse. These are supervised processes, not passive resets. Chapter 7 can remain on a credit report up to 10 years, Chapter 13 up to 7 years, and Chapter 11 varies, but has significant reporting impact. However, many filers begin rebuilding credit within 12 to 24 months, post-discharge or confirmation. The filing is a financial event. Long-term impact depends more on behavior afterward than on the chapter itself. Bankruptcy chapters are not identity markers. They are structural responses to financial facts. If someone is considering bankruptcy, the evaluation order should be 1. Income relative to state median. 2. Total debt amount. 3. Asset exposure. 4. Secured debt status. 5. Business involvement. That analysis determines the chapter. Chapter determination is not a preference, is not done out of frustration, nor is it done out of fear of the outcome. It is a matter of structure, and structure determines outcome.
If you like this content, then kindly hit like, subscribe, and share. Caesar commands it.